Florida's Slayer statute in the context of estate and probate litigation. Who inherits if somebody causes the death of a decedent? Can you inherit from a Florida probate or a Florida estate if you cause the death of somebody? And more so, can your children, if they're beneficiaries, inherit from the deceased person if you cause that person's demise? My name is John P.L.C. I'm a probate litigation attorney in Florida with the P.L.C. law firm. I'm going to be speaking to you now about an interesting issue regarding Florida's Slayer statute and also having a discussion with you about whether children of the slayer may inherit from the decedent's estate. So most probate lawyers know that Florida has a slayer statute. If you cause someone's demise, you cannot inherit from that person. Okay, consider this scenario. A spouse or a loved one or someone who is very close to an individual asks that person or individual to sign a will. And that person signs a will and lets this person inherit and lets this person's children from a prior relationship inherit. Now, if this person passes away and this person caused that decedent's death, will the killer, the slayer, inherit from the decedent's estate? Florida probate law says no. We have a slayer statute. You cannot benefit from the demise of somebody whose death you cause. However, what about the killer or the slayer's children from a prior relationship? What if those children are named as beneficiaries of the decedent's estate? Can this person, these individuals, these beneficiaries, can they inherit from the decedent's estate? And the answer is yes. The slayer statute in Florida only prohibits the actual slayer or killer from inheriting from the decedent's estate. Most Florida probate litigation attorneys will tell you that's the case. But an interesting case considered the issue of whether the slayer's children can inherit. The answer is no. An appellate court refused to extend the slayer statute to exclude children of the slayer from inheriting. So if a person has a will, has a probate, and has a Florida probate lawyer draft a will that names somebody as a beneficiary, and also that beneficiary's relatives or loved ones, those relatives or loved ones may inherit from the probate or the estate even if their loved one or parent caused the death of the decedent. The next question that can arise is, was the will the product of undue influence? Did the slayer or the killer coerce or force or pressure the decedent to execute the will? That can be tried in a Florida probate court, and the will could indeed be set aside, or a provision of the will could be set aside based on undue influence. For those people who are interested in this fact pattern, you could look at the P.L.L. case, F-I-E-L, F as in Frank, I-E as in Edward, L as in Larry. It's a 4th District Court of Appeal case from July 29, 2015. There was a trial, there was a probate down in Broward County. This made its way up to Florida's 4th District Court of Appeal, which hears probate and guardianship and trust appeals for Broward County and Palm Beach County. The case number is 4D, 4th District 14, a 2014 case, 1048. The frustrating part for the family of the decedent is that this decedent had a will that left everything to the slayer and the slayer's children or relatives from a different or prior relationship. That had to be frustrating to the decedent's family, because one would think that the person who was killed and who is the subject of this Florida probate, if they knew that someone they inserted as a beneficiary was going to cause their death, they wouldn't name them as a beneficiary of their Florida estate under their Florida will, and they probably wouldn't name the slayer or the killer's children from a prior relationship as beneficiaries. So this can cause Florida estate lawyers or Florida probate attorneys to consider, when you're drafting an estate plan for a client, should you make as a condition of an inheritance that somebody doesn't cause one's demise? You can see that Florida probate lawyers could easily draft around this issue by saying, for example, I leave my estate to my friend John, providing John doesn't cause my demise, and I leave part of my estate to John's children from a prior relationship, conditioned on John or those beneficiaries not causing my demise. If any of these members of this class of beneficiaries or these beneficiaries cause my death, they shall receive no inheritance under my estate or my probate. Florida's slayer statute, an interesting Florida probate litigation topic, and this concludes my remarks on this probate litigation issue.